That 8-to-1 Supreme Court headline flying around online sounds like your carry rights changed overnight. But if you trust the wrong version of this story, you could walk into the wrong place with a gun and learn the real rule the hard way. Before we go 1 inch further, let me ask you something. Are you subscribed yet? Because this channel is built for people who want the truth before a traffic stop, before a courtroom, and before a mistake turns into a felony. Hit that button now, because what I'm about to explain could save you from making a very expensive decision. Here's what just happened, and here's the first thing most people get wrong. The real 8-to-1 Supreme Court gun case was not a case that erased carry permits. It was not a case that suddenly made every state go permitless. And it was not a case that said you can carry anywhere you want. The case was about a federal law that blocks gun possession for people under certain domestic violence restraining orders. The Supreme Court upheld that law by an 8-to-1 vote. That means 8 justices said the restriction could stand, and 1 justice disagreed. So if you saw a headline saying the court dropped an 8-to-1 firebomb on gun law, that part is real. But the spin after that is where people get lost. Let me break this down for you in plain English. The court said modern gun laws do not need a perfect copy from the 1700s to survive. That is huge. That is the part nobody's talking about, clearly enough. The justices basically said courts should look for a strong historical cousin, not an identical twin. In simple terms, if an older American tradition dealt with the same kind of danger in a similar way, a modern law may still be constitutional. Now, why does that matter to you if you are just trying to carry legally and protect your family? Because carry rules are fought in court using that exact test. Not your feelings, not a viral thumbnail. That legal test. Think about it like this. Before this ruling, a lot of people believed many gun restrictions would fall unless the government found an almost exact match from early American history. After this ruling, states got a stronger argument. They can now say, we do not need a perfect old law. We need a relevant historical example that tackled a similar risk. But here's the crazy part. This does not mean every carry restriction suddenly becomes legal. It just means the government got a better roadmap for defending some restrictions in court. Second thing you need to understand, this 8-to-1 ruling did not overrule Bruen. Bruen is still the major Supreme Court case, saying the Second Amendment protects carrying a handgun in public for self-defense. That part still matters, a lot. Bruen killed New York's old proper cause rule, where regular people had to show a special reason to carry. So public carry is still protected. That did not vanish. What changed is the way lower courts may apply that history test going forward. And that is where your daily carry routine can be affected, even if your permit card still looks exactly the same in your wallet. Here's a simple example. Imagine you have a valid carry permit. You walk from a public sidewalk into a crowded train station or a posted private business, or a place your state labels as sensitive. Most people think, I have a permit, so I'm good. But the truth is, your permit is not a golden ticket. It never was. A permit may let you carry in general, but it does not cancel location bans, private property rules, training requirements, or local restrictions that courts have allowed to stay in place. And that is why this story matters right now, not because your permit disappeared overnight, but because the legal ground under your feet shifted. And states are using that shift to defend more carry limits than many gun owners expected. If this is helping you cut through the noise, imagine what you'll get from the next video, where I break down the exact sentence that can keep you from talking too much during a police encounter. Subscribe now so you don't miss it, because knowing the law is good, but knowing what to say under pressure is even better. Now let's go to the second part, because this is where it gets interesting. The big fight after Bruen has not really been about whether you can carry at all. The fight has been about where you can carry, what hoops your state can make you jump through, and how narrow your freedom becomes once lawmakers start naming sensitive places. And this is the part that shocked me when I looked at how courts are handling it. In New York, major parts of the post-Bruen carry law have stayed in place. We're talking about training requirements, interviews, character references, and a good moral character standard for getting a permit. Courts have also let restrictions stay in force for places like Times Square, the subway, and commuter rail lines, while the legal battles continue. Read that again in practical terms. A person can legally qualify for a permit, do the classes, pass the checks, get the license, and still enter a place where that gun becomes illegal the second they cross an invisible line. Have you ever wondered why so many gun owners feel confused right now? That is why. The argument is no longer just, can I carry? The real question is, can I carry here, 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 and here? And if the answer changes every few blocks, you have a serious problem. Here's a hypothetical example to explain this. Say you are driving into the city. You are licensed, you stop for gas, then you grab food, then you take a train, then you walk through a crowded tourist area. Your gun may be legal in the car, questionable at one stop, banned at the next location, and totally off limits by the time you hit the station. Same person, same day, same firearm. Different legal result every few minutes. That is why headlines can be dangerous. They make people think in giant, simple boxes: win or loss, carry legal or carry illegal. Real life is way messier than that. Now, quick legal note: this is educational information, not legal advice. Always consult an attorney for your specific situation. Third thing, the Supreme Court recently refused to step in and wipe out New York's good moral character carry rule, at least for now. That means a lot of New York's carry system remains standing while more litigation plays out. So when someone tells you the Supreme Court just crushed carry permit rules instantly, ask them one question. If that's true, why are big parts of those rules still on the books? But wait, there's something even more important. Some private property carry rules are still under active attack. In other words, the story is not over, not even close. And here's what most people get wrong. They think the next big change will come from a dramatic full ban or full win. More likely, the biggest changes will happen through location rules. Private businesses, restaurants, stores, hotels, parking areas, transit systems, event spaces. That is where your everyday carry life is really being shaped. Picture a traffic stop for a second. An officer asks where you're headed. You say you're going to dinner. Sounds harmless, right? But if that dinner spot is in a place where carry is restricted or the property has a rule you missed, the legal risk can turn fast. Not because you were a bad person, not because you had criminal intent, but because the map in your head did not match the law on the ground. Hey, real talk. Most viewers watch this stuff, nod along, and then never come back until there's a crisis. Don't be that person. Join the community that stays ahead of the changes instead of learning about them from a lawyer after the fact. Hit subscribe and stay in front of the next ruling. Now let's talk about Hawaii, because this may be where the next major carry shockwave comes from. There's a case challenging Hawaii's rule that says, in simple terms, you generally cannot carry on private property open to the public unless the owner says yes. Think malls, hotels, stores, and other everyday places. A lot of people call that a vampire rule because you need permission to enter while armed. At oral argument, several justices sounded skeptical of Hawaii's position. That is important. But listen carefully. As of right now, there has not been a final Supreme Court decision in that case yet. So if someone online tells you the court already nuked those rules nationwide, slow down. That is not where things stand. This is the part nobody should ignore. If the court eventually strikes down Hawaii's approach, that could matter far beyond Hawaii. Why? Because several states tried similar ideas after Bruen. They looked at public carry becoming more protected and responded by saying, fine, then we'll make huge chunks of public-facing private property off limits unless owners opt in. Most people think private property rules are small side issues. They are not. They may decide whether your carry permit is useful in normal daily life or mostly trapped to a few narrow spaces. Let me make this personal. Imagine you finally get your permit after months of paperwork, money, training, and waiting. You want to protect yourself during normal errands, grocery store, pharmacy, coffee shop, gas station, shopping center. If the law says you can carry on the sidewalk but not inside half the places you actually go, then your right starts shrinking fast in the real world. That is why I say the carry fight is no longer just about owning the permit. It is about whether the permit means anything once you leave home. Now, this is where you need a practical plan. First, stop trusting headlines that sound too clean. If a title says everything changed instantly, assume there is missing context. Second, separate 3 questions in your mind. Can you carry at all? Where can you carry? What conditions must you meet to keep carrying legally? Those are 3 different battles. Third, know your sensitive places list. I know it is boring. I know it changes. I know it feels unfair in some states. Learn it anyway. Fourth, treat private property as a legal danger zone unless you know the rule in your state. Fifth, if you live in a state with heavy restrictions, follow the pending cases closely because one ruling can change your options fast. And don't make this mistake. Do not assume that because a case sounds pro-gun, it automatically gives you permission today. Court decisions can be narrow. They can send cases back down. They can leave parts of laws standing. They can fix one problem while leaving 5 others untouched. So what is the honest takeaway from this so-called 8-to-1 Supreme Court firebomb? Here it is. The Supreme Court did issue a real 8-to-1 gun ruling. It did reshape the legal argument. It did give governments stronger language to defend some restrictions. But it did not instantly erase all carry permits. And it did not instantly settle where you can carry in every state. One more thing before I close. The next major carry decision could drop fast, and when it does, the people who wait for social media rumors will be the last to understand what changed. Subscribe right now because the next update may tell you exactly where your permit works, where it doesn't, and what you need to change that same day. So here's the bottom line. Your carry rights did not vanish overnight, but the rules around them are being shaped in real time by the Supreme Court and lower courts. The danger is not just losing a case. The danger is thinking you understand the law when you only know the headline. If you want straight answers without the fluff, subscribe and stick with me, because these cases are moving, and the people who stay informed are the people most likely to stay free. And final reminder, this video is for education only. Laws vary by state, facts matter, and if you need advice for your own situation, talk to a qualified attorney before you carry.